No, the fact that cannabis consumption is legalized for recreational purposes does not change anything with respect to cannabis use in the workplace. Employers have the obligation to provide a safe and healthy workplace to all employees, which includes ensuring that employees are not under the influence of any substance that may cause impairment. Employers can still expect and require that employees come to work and remain throughout their workday fit and capable of performing their duties. The legal status of cannabis does not allow employees to use it at work or be under its influence while at work. Employers will not be allowed to distribute, sell, encourage, tolerate the use of cannabis, or make it available to employees at social events. Employers can choose to ban cannabis at work in the same way that they can ban alcohol. All policies related to cannabis need to clearly outline all rules and regulations surrounding the recreational drug. It is also important to clearly communicate these bans to all employees. Without clear rules and regulations, an employee could legally bring cannabis into the workplace. In most cases, no. Employers can't prohibit their employees from using cannabis off the clock, as it will be a legal recreational drug. There are certain circumstances in which an employer can prohibit its use. For example, if an employee is in a highly safety-sensitive role and any impairment would have serious consequences. In such a case, when the employer has no ability to check an employee's possible impairment, it may be possible to require that the role be carried out by employees who do not use cannabis. This, however, would be a rare circumstance. Testing should only be used in limited circumstances. Some examples are after an incident or accident, for a safety-sensitive position, or if reasonable grounds exist to suspect that an employee is working under the influence of a drug. Random or arbitrary testing should be avoided altogether, save for these exceptional circumstances.